Okay, I need to tell you something, and I need you to stay with me, because what happened this morning in federal court changes everything, not incrementally, completely. For over a year, Donald Trump's legal strategy has operated on one fundamental premise: delay, file motions, appeal every ruling, challenge every procedure, request continuances, demand hearings. The goal was never to win on legal merits. The goal was to push everything far enough into the future that circumstances would change. Maybe the political landscape shifts. Maybe public attention fades. Maybe a friendly administration takes power and makes the problems disappear. That strategy just died. The Supreme Court ruled on presidential immunity, the D.C. Circuit closed the self-pardon loophole, and this morning, a federal judge issued an order that removes the final legal shield Trump's team was counting on. What remains is a former president with no immunity protection, no valid procedural defenses, no delay mechanisms, and a clear path to sentencing that cannot be stopped. If you're just joining us, understand this: in 48 years of American constitutional history, the Supreme Court has never been forced to rule on whether a former president can be criminally prosecuted for conduct during their term. Presidents have resigned before prosecution could begin. Presidents have been pardoned by their successors. Presidents have avoided charges through political arrangements that kept them out of courtrooms. But no court has ever had to decide whether the office itself creates immunity from criminal consequences after leaving power, until this term. And the answer the court delivered removes the entire foundation Trump's defense was built on. The immunity argument is dead. The self-pardon theory is rejected. The delay strategy is exhausted. And the procedural exits have been sealed. Let me walk you through the legal framework the Supreme Court established, because every detail matters here. Chief Justice John Roberts wrote the majority opinion. 6 justices joined it. 3 dissented. The framework divides presidential conduct into 3 distinct categories. First, core constitutional functions. These are powers explicitly granted by the Constitution: pardoning federal offenses, vetoing legislation, appointing federal officials, commanding the military in lawful operations. For these core functions, the president has absolute immunity. No criminal prosecution is possible for actions within this category, regardless of intent, motivation, or outcome. This immunity is complete and cannot be overcome by any showing of criminal purpose. Second, official acts outside that narrow core. These are actions taken in the president's official capacity, but not involving core constitutional powers. For these acts, the president has presumptive immunity. This means prosecutors can overcome the immunity, but they must demonstrate that the conduct was criminal and that prosecution won't interfere with legitimate executive functions. This is a high bar, but not an insurmountable one. Third, unofficial acts. Actions taken as a candidate. Actions taken as a private citizen. Actions taken as a political operative, pursuing personal interests. For these acts, there is no immunity whatsoever. None. These actions are subject to criminal prosecution, exactly like conduct by any other American citizen. Now here's where Trump's entire defense collapses. The charges he's facing don't involve core constitutional functions. They involve attempting to overturn an election he lost, pressuring state officials to alter vote counts, organizing fake electors to submit fraudulent electoral certificates, inciting supporters to stop the certification of electoral votes. Under the Supreme Court's framework, none of those actions qualify as official presidential acts. They're campaign activities. They're personal attempts to remain in power after losing an election. They're conduct undertaken to benefit Donald Trump, the candidate, not to fulfill duties of the presidency. And under the ruling issued by the Supreme Court, they receive absolutely zero immunity protection. Trump's lawyers immediately filed appeals, arguing that because some of this conduct occurred while he was president, it deserves official act protection. The timing should matter, they argued. If you're president when you do something, it's an official act. The D.C. Circuit Court of Appeals rejected that argument in a unanimous decision. The 3-judge panel, which included judges appointed by both Republican and Democratic presidents, held that timing is irrelevant. What matters is the nature of the act itself. And attempting to overturn an election you lost is not a presidential function regardless of when it occurs. The opinion is devastating. It states that Trump's interpretation of presidential power would effectively place the president above the law in ways the framers explicitly rejected when they designed the Constitution. And this is where everything breaks. The Circuit Court went further. They noted that if Trump's argument were accepted, a president could commit virtually any crime while in office and claim immunity simply because the crime occurred during their term. That interpretation, the court stated, is absurd on its face and constitutionally indefensible. The ruling makes clear that the question isn't when you did something. The question is why you did it, and whether it falls within legitimate presidential authority. Overturning an election doesn't fall within that authority. It's not in the Constitution. It's not an implied power. It's not a legitimate function of the office. It's a crime, and it receives no immunity protection. Trump's legal team then attempted one final procedural maneuver. They filed an emergency petition with the Supreme Court, asking for a stay of proceedings while they prepared a full appeal of the D.C. Circuit's ruling. This was the last hope. If the Supreme Court agreed to hear the case, it would delay the trial by months, possibly pushing everything past the November election. But the Supreme Court denied the petition, not in a lengthy opinion with detailed reasoning, not with competing views from different justices. Just denied. One sentence, no explanation required, no dissent registered, complete rejection. That denial came down 6 days ago, and it meant that every legal question about presidential immunity had been definitively resolved against Trump. No more appeals are available, no more procedural delays are possible. The immunity defense is completely dead. If accountability matters to you, if you believe no one should be above the law, subscribe to this channel right now. But Trump's attorneys still had one card left to play. They filed a motion arguing that even if immunity doesn't apply, Trump deserves additional time to prepare for trial, given the case's unprecedented complexity. They requested a 6-month delay. They cited the enormous volume of evidence. They noted that witnesses are scattered across multiple states. They argued that the legal issues are novel and require extensive preparation. These are standard arguments defense attorneys make in complex federal cases, and judges often grant reasonable delays under these circumstances because defendants have a constitutional right to adequate time to prepare their defense. But here's what Trump's legal team failed to account for. Judge Tanya Chutkan has been presiding over this case for over a year. She's watched motion after motion filed for the sole purpose of consuming time. She's observed appeal after appeal designed not to prevail on the merits, but simply to delay proceedings. She's seen Trump's public statements attacking witnesses, attempting to intimidate prosecutors, trying to poison the jury pool. And she's concluded that the time for procedural gamesmanship has ended. The order she issued this morning is the judicial equivalent of a steel door slamming shut. No more delays, no more continuances, no more extensions. The trial proceeds on schedule. Judge Chutkan writes, and I'm quoting directly from the order, that the defendant has exhausted every available appellate avenue. The immunity questions that formed the basis for previous delays have now been resolved definitively by the Supreme Court of the United States. The defendant has had over 14 months since the indictment was returned to prepare his defense. During that time, his legal team has filed dozens of motions, pursued multiple appeals, and engaged extensively with the evidence. No further delay is warranted, justified, or will be entertained by this court. She goes on to note something particularly damning. Trump's own public statements demonstrate comprehensive knowledge of the case that contradicts his claims of inadequate preparation. She cites his detailed public commentary on specific pieces of evidence, his attacks on particular witnesses by name, his discussions of legal strategy in media interviews and social media posts. All of this, she observes, demonstrates that Trump and his legal team are thoroughly familiar with the case and have been actively preparing for trial while simultaneously claiming they need more time. And here's the part that seals everything. Judge Chutkan explicitly invokes the Speedy Trial Act. That federal statute requires criminal trials to begin within 70 days of certain triggering events, unless the court finds good cause for delay. She holds that the immunity appeals constituted good cause for the delays that have already occurred. But those appeals are now exhausted. The Supreme Court has ruled, the questions are answered, the statutory clock has run its course, and the Speedy Trial Act now mandates that the trial proceed without further postponement. She's not simply saying the trial will happen, she's saying federal law requires it to happen. She's removed her own discretion to grant additional continuances. Any further delay would violate both the defendant's statutory rights under the Speedy Trial Act and the public's interest in timely justice. The trial date is March 4th, 28 days from now. Jury selection begins that morning. Opening statements follow shortly after, and the trial proceeds until a verdict is reached. Nothing short of a genuine emergency can stop it now. Here's what this means practically. Trump's entire legal strategy was built on keeping the trial date flexible. If they could delay proceedings until after the November election, political pressure might force further postponement. Maybe Trump wins the presidency and federal charges disappear. Maybe public opinion shifts. Maybe something breaks their way. But that strategy required maintaining the possibility of continued delay. Judge Chutkan just eliminated that possibility entirely. March 4th is locked, immovable. The machinery of trial begins that day and continues until 12 citizens render a verdict. The evidence prosecutors will present is overwhelming. Mike Pence, Trump's own vice president, will testify that Trump pressured him repeatedly to reject electoral votes and became enraged when Pence refused. Mark Meadows, Trump's own chief of staff, has provided extensive testimony about Oval Office meetings where the scheme to overturn the election was planned and discussed. Pat Cipollone, Trump's White House counsel, will testify that he repeatedly warned Trump the conduct was illegal and unconstitutional. Cassidy Hutchinson will describe in detail what she witnessed in the days leading up to January 6th. And then there are the recordings, the phone call to Georgia's Secretary of State, where Trump explicitly asks him to find exactly enough votes to change the outcome. The speech on January 6th, where Trump tells supporters to march to the Capitol and fight. Audio and video evidence that cannot be explained away, cannot be recontextualized, cannot be dismissed. All of it admissible in court, all of it devastating to the defense. And here's the part most people are missing. This ruling doesn't just affect the federal case in D.C. It affects every case Trump is facing. Because the legal framework is now established by the highest court in the nation. The Supreme Court has ruled that unofficial acts receive no immunity protection. The D.C. Circuit has held that attempting to overturn elections falls outside presidential authority. Judge Chutkan has held that delay tactics have been exhausted and trials must proceed. Every other judge handling Trump's cases can now cite these rulings. The Georgia prosecutors pursuing RICO charges can point to this framework. The Florida judge handling the classified documents case can apply the same immunity standard. The New York judge overseeing financial fraud charges can reference these holdings. Trump's strategy has been to fight each case separately, hoping to win procedural victories in different jurisdictions that create indefinite delays. But now the legal framework applies uniformly across all cases. The immunity defense is dead everywhere. The delay strategies are exhausted everywhere. The trials are approaching in every jurisdiction, and they're all happening before the November election. This is where most criminal defendants facing multiple prosecutions reevaluate their entire approach, when every legal defense has failed, when the evidence is overwhelming, when multiple trials are imminent. Cooperation with prosecutors becomes the rational strategic choice. You provide information, you cooperate with ongoing investigations, you accept responsibility for your conduct, you negotiate for reduced sentences in exchange for truthful testimony. It's not weakness, it's reality. It's what defense attorneys advise clients to do when fighting becomes futile and the goal shifts to minimizing damage. But Donald Trump refuses to even discuss plea negotiations. His entire identity, his entire public persona is built on a foundation of never admitting defeat, never acknowledging error, never showing weakness. That psychological stance, whatever personal satisfaction it provides, maximizes his legal exposure catastrophically. Because if he proceeds to trial and conviction occurs, federal judges have very limited discretion to depart downward from sentencing guidelines. And for the crimes Trump is charged with, those guidelines are severe. Let me walk you through the sentencing mathematics that Trump's legal team is looking at right now. Conspiracy to defraud the United States carries a maximum sentence of 5 years per count. Obstruction of an official proceeding carries up to 20 years. Conspiracy against rights carries up to 10 years. If Trump is convicted on multiple counts, even if sentences run concurrently rather than consecutively, he's looking at substantial federal prison time measured in years, not months. And that's just the D.C. case. Georgia's RICO charges carry their own sentencing exposure. The classified documents case in Florida has its own potential sentences. The financial fraud case in New York operates entirely independently. Each conviction in each jurisdiction creates separate sentencing consequences. The combined potential exposure is measured in decades. Sources inside Trump's legal operation describe the atmosphere as chaos mixed with denial. Senior attorneys are frantically preparing for a trial that begins in 28 days. They're finalizing witness lists. They're preparing cross-examinations of prosecution witnesses. They're developing jury selection strategies. They're drafting opening statements. This is enormous work that typically takes months, and they're trying to complete it under crushing time pressure. But Trump himself is reportedly in complete denial about the timeline. He remains convinced that something will intervene at the last moment, that the Supreme Court will step in again, that Judge Chutkan will be forced to grant a delay, that circumstances will somehow change. His attorneys are trying desperately to explain to him that none of those things are going to happen. The Supreme Court has already declined to intervene. Judge Chutkan has explicitly foreclosed further delays. The trial is happening in 28 days, whether Trump accepts that reality or not. Several senior attorneys have already withdrawn from Trump's legal team. Others are reportedly considering it. The challenge they face isn't just the compressed timeline or the strength of the prosecution's evidence. It's representing a client who fundamentally refuses to accept that the legal system has authority over him. Trump continues posting on social media, attacking the judge personally, attacking witnesses by name, claiming the entire proceeding is rigged and illegitimate. Every post creates additional potential grounds for contempt of court. Every attack on a witness strengthens prosecutors' arguments about obstruction and witness intimidation. His lawyers are begging him to stop. He's ignoring them completely, because acknowledging the seriousness of his situation would require acknowledging that he might actually lose, and that's something Donald Trump appears psychologically incapable of doing. Let me tell you what constitutional scholars and former prosecutors are saying about this moment. Professor Lawrence Tribe of Harvard Law School stated this morning that Judge Chutkan's order represents the American judicial system, finally definitively asserting that former presidents are subject to the same legal processes as every other citizen. No more special treatment, no more endless procedural delays, no more institutional presumption that prosecuting a former president is simply too disruptive or too politically fraught to attempt. The system is treating Trump exactly as it would treat any other defendant facing the same charges with the same evidence. Professor Michael McConnell of Stanford Law School, a respected conservative legal scholar, acknowledged that while he has concerns about the potential criminalization of political disputes, the charges Trump faces involve clear criminal conduct, not policy disagreements. Attempting to overturn an election through fraud and intimidation is a crime. And once someone is charged with crimes, regardless of their former position, they don't get to delay proceedings indefinitely simply because they once held high office. Former federal prosecutor Andrew Weissmann, who served on Robert Mueller's special counsel team, stated that Trump's legal options have now been reduced to exactly one: go to trial and hope the jury doesn't convict. There are no more procedural maneuvers available, no more immunity defenses to raise, no more delay tactics to pursue. The only question remaining is whether 12 citizens, after hearing all the evidence, will vote to convict beyond a reasonable doubt. That's it. That's all that's left. March 4th, jury selection begins. The process will take days, possibly weeks, depending on how difficult it is to find impartial jurors. Both sides will question potential jurors extensively. Trump's attorneys will look for jurors who are skeptical of government authority, sympathetic to claims of political persecution, potentially favorable to Trump personally. Prosecutors will look for jurors who can set aside any political views they might hold and focus purely on the evidence presented. Eventually, 12 citizens will be seated in that jury box, and they will hear everything, every witness, every recording, every document, every piece of evidence the prosecution has compiled. And then they will deliberate. Not based on their political preferences, not based on who they voted for in previous elections, but based on whether the evidence proves the charges beyond a reasonable doubt. If conviction occurs, sentencing follows within weeks under federal procedures. Federal judges are required to calculate sentencing guideline ranges based on the nature of the offense, the defendant's criminal history, and various other factors. For the charges Trump faces, those guideline ranges are severe. Judges can depart downward from the guidelines if mitigating factors exist, but Trump has shown no remorse whatsoever. He's continued attacking the judicial system throughout the proceedings. He's demonstrated no acceptance of responsibility. He's shown no recognition that his conduct was wrong. Those factors all weigh heavily against any leniency in sentencing. Most legal analysts following this case expect that if conviction occurs, meaningful prison time will follow. Not home detention, not probation, federal custody. Think about what that means for American politics. A major political party's frontrunner for the presidential nomination conducting a campaign from federal prison. Secret Service agents providing protection inside a detention facility. Campaign appearances limited to video feeds and recorded messages. Fundraising operations run entirely by surrogates. Political rallies impossible to hold. The entire machinery of a presidential campaign fundamentally transformed by the candidate's incarceration. It's never happened in American history. There's no precedent for it. There's no established playbook. Both major political parties would be navigating completely uncharted constitutional and political territory. The Supreme Court has ruled. The appeals are exhausted. The trial date is locked. The evidence is ready. The witnesses are prepared. In 28 days, a former president of the United States will sit at the defense table in a federal courtroom while prosecutors present evidence that he attempted to overturn an election, that he pressured state officials to falsify vote counts, that he organized fraudulent electoral slates, and that he incited violence to prevent the peaceful transfer of presidential power. 12 citizens will decide whether those actions constitute federal crimes. And if they conclude that the evidence proves guilt beyond reasonable doubt, sentencing will follow. This is American democracy, conducting the ultimate stress test of the principle that no person in this country, regardless of how powerful they once were, regardless of how wealthy they are, regardless of what office they previously held, is above the law. The test is happening right now. The legal system is responding. And what happens over the next few months will be studied and debated for generations as the moment when America either proved that principle still has meaning or revealed that it was always just an aspirational slogan without real enforcement power. Subscribe to this channel for continued coverage of every development in this case. Turn on notifications so you see updates the moment significant news breaks. Share this video with anyone who needs to understand the legal framework that now governs presidential accountability in America. The legal walls have closed in. The procedural exits have been sealed, and the machinery of criminal justice is now in motion. Stay informed, stay engaged, because the rule of law is being tested, and the answer to whether it still functions is about to be written in a federal courtroom 28 days from now.